I do want to honor your willingness to our time. If it's all right, I'm going to say a quick prayer. I'll make an introduction, and then I'm going to hit the mute button, and we'll go from there. So let's take a moment to be in prayer. Gracious God, as we gather in this time, we thank you for our opportunities. Help us to continue to have our hearts, our minds, our ears open, to knowing how you would have us continue to be about building your kingdom here on earth. Amen. Okay, allow me to introduce Mr. Andrew Loudon, attorney at law. Thank you very much, sir, for coming. He is partners in Bell, Loudon, Ebert, and Brostrom. Did I do that right?
Close.
Okay. Sorry that I don't tell whoever's name I butchered that I butchered it.
It's
so
okay.
I apologize for that, but I thank you for giving us your time. And I'm going to hit mute and let you just go with it.
Okay. Thank you, Matt. And thank you, everybody, for the invitation. I'm honored to speak with all of you. Our law firm is honored to serve as legal counsel for the Nebraska United Methodist Foundation. And our group has worked with you for many years. The founder of our group, Doug Deichler, was the chancellor for the annual conference for many decades. So that was our original connection with the Nebraska United Methodist Foundation, and we value our relationship with you. Our law firm does a lot of public speaking at churches. And at the outset, I'll just mention that any one of us, my three law partners are Christy Ball, Brett Ebert, and Kara Brostrom. Any one of us are available to speak at your congregations on planned giving. We would do something very similar to what I'm going to present to you today. And we do it in a non-solicitous manner. We are very careful not to solicit business. I think that's inappropriate in an educational setting, especially mindful not to offend any of your parishioners who are attorneys. In fact, we have found it helpful to come alongside and present with an attorney who's a member of your congregation. Our focus at that presentation would be planned giving for the local church. And I am a firm believer that it is only mainline Protestant churches who do effective planned giving over the next 2 decades who will be able to afford pastors and buildings in the next generation. I come on it pretty straightforward with congregations when I speak with them. I come from a personal perspective. I am the son and brother of a Presbyterian minister. My father just retired 2 years ago. But my brother is an active PCUSA pastor in Ohio, and especially he's in his late 30s. He's nervous about the rest of his career, and his current congregation is well endowed, but the last 2 that he had are not, and the future is kind of scary for those his first 2 congregations because of that. So I will just mention a couple strategies for this group as well as we get into it. But to add value to your time, I'm going to run through these mistakes, and perhaps this will help you personally. I hope it does. Perhaps it will inspire you to ask some other questions of your own attorney or financial advisor or accountant. And again, appreciate being here. By the way, I'm live here from Grand Island, Nebraska. Our law firm is headquartered in Lincoln, in Williamsburg, on the south side of town, but we have offices in Omaha, where we are every week at 92nd and Dodge, and here in Grand Island, where we are every week on West 2nd Street. So we have a statewide practice and are blessed in that regard. So I have learned the most in my 22, almost 23 years as an attorney in estate planning and estate administration, which means every day I work with families planning for the transfer of their wealth. That's estate planning. And every day we work with families after a loved one has passed away. That is estate administration. I have learned the most about what people should and should not do by working on estate administration after somebody dies. That's when the rubber hits the road. That's when we see if the estate plan really worked. And my goal with this these top 10 mistakes for you today is that you and your family or your parishioners will not make these mistakes, and that will save heartache and expense after somebody passes away. By the way, Matt and I didn't talk about this, but I'm super comfortable with questions. That does not throw me one bit. So if you have questions, the best part about today is you don't get a bill from me. So if you have a question, that is super cool. So just, I don't know if you can put it in the chat or even unmute. It's not going to faze me one bit. So going off the handout that you received, I'm kind of like David Letterman. I do in the descending 10 to 1 order. The 10th mistake that I've seen a lot of people make is no planning at all. Now, you may have read, and it is true, that a majority of Americans don't get around to doing estate planning at all. We work with many families where mom and dad, grandma and grandpa never did a will. And that might surprise professionals who are organized and think about planning, but it doesn't surprise us because we know it to be true because we live it every day. And it's really tragic. The one that breaks my heart right now is a friend of mine from college who was an executive at Union Pacific Railroad and died of COVID at age 51. So we never know what's going to happen or when our hour will be. And it's most 51-year-olds are not dying of COVID, but it can happen. And that's one I'm dealing with right now. And so the mistake here is obvious, and that is getting your affairs in order is important so that your property goes where you want it to go when you pass, and that the people you want to be in charge are in charge after you pass away. Now, one thing that you might not know, and I find that most lay people do not know, is that in Nebraska, a spouse does have rights to an inheritance. Now, children do not have a right to an inheritance. Now, most kids think they have a right to an inheritance, but they do not. In the United States, children do not. In some countries like France, children do have a right to inherit from their parents, but that's not true under British common law here in the United States. However, it is true that a spouse has an absolute right to the first 100,000 plus 1/2 of her or his spouse's estate. This plays itself out in very interesting and unexpected ways, especially in second marriages. Imagine, if you will, a second marriage where the woman comes into the marriage owning a farm in Nebraska that she inherited from her parents, and her husband comes into the marriage with a car, and that's about it. And they get married and they buy a house together. And in the will, maybe the wife says, well, I would want my husband to have the house when I die, and maybe our joint personal property and checking account. But that farm that I inherited from my parents, I want my children from my first marriage to have that farm. Then if the wife dies before the husband, in my make-believe scenario here, guess what? Her will could be invalidated easily by the surviving spouse. If he chose, it's called an elective share, the surviving spouse could take the first 100,000 plus 1/2 of the entire joint estate. And with the Nebraska farm, it's probably going to be, that value is probably going to be more than half the estate. Then he's going to be able to probably force the sale of the farm regardless of what his wife's will said. That catches a lot of people unaware. And it's a big issue, especially in second marriages, especially with farm ground in Nebraska. What I just described that right to take from your spouse's estate can be waived through a prenuptial agreement or a postnuptial agreement. A prenuptial agreement is one that's signed before you get married. A postnuptial agreement is one that's signed after you get married. A postnuptial agreement is not effective for divorce, but it is effective in what I'm talking about, and that's a claim at death. That's something that a lot of people don't know, and I try to mention at educational seminars because it really catches families unaware. And also I should add, and this is a little scary, in Nebraska, the person who's surviving, they could be incapacitated and their power of attorney could make this election. I have seen that happen where folks in a second marriage, of course, they would say to each other, well, I would never do that. I would never take that farm from your kids. But then the wife dies first, and now maybe dad has Alzheimer's or the husband has Alzheimer's. He's not the dad, he's the second husband, the stepdad. His power of attorney, maybe his kids, can elect and take that farm. So it's kind of scary, something to think about. The ninth mistake that I see a lot of people make is waiting until the last minute to plan. And this is one that we're encountering a lot. It's easy to put off estate planning. It's not fun to talk about your demise. And it's not fun to go see the lawyer, although I try to make it pretty fun. I try to make talking about death and mental incapacity a good time, believe it or not. But it's not the best favorite topic of everybody. So unfortunately, about once a month, we're getting calls from people who have received a bad diagnosis. And we need to fly to their relief right now. And we do. We go to the hospital. We go to the rehabilitation center. We go to the assisted living facility, the hospice centers. And we walk into that room, and I'll tell you folks, that is the wrong time to be doing estate planning at the last minute for two reasons. Number one is we, as attorneys and not medical professionals, need to come to a conclusion that the person has mental capacity. Well, as a layperson in regard to medical issues, I'm not going to make that determination if I have any guess as to whether this person has mental capacity or not. If it's a little iffy, we're going to back off and wait for a doctor to give us a written opinion that the person has mental capacity. Sometimes we don't have the time for that delay, and it really frustrates families. But ethically, it's extremely important for a lawyer to know that the person knows who they are, knows what they own, and who they want to have it. And so we have to make that determination, which at the end of life, you all know as pastors who are with many people at the end of life, it's sometimes someone knows who they are in the morning and doesn't know who they are in the afternoon. So it can be kind of tenuous. The second reason putting this off to the last minute is a bad idea is undue influence. So oftentimes when I walk into that hospital room, there's mom in the bed, and who almost always is in the chair next to her? Adult child. Usually the adult child who's the healthcare power of attorney. And I'll maybe start the meeting by saying, Mom, what would you like to talk about today? And then the response comes not from mom, but from adult daughter. Well, mom wants to do this. Okay. Well, at that point, I have to politely excuse the adult child from the room. I'm 48 years old. Oftentimes, the adult child is my elder. So it feels kind of rude, but I have to do it. And sometimes they're not real happy about it. But ethically, again, it's important for me to have a conversation with the client, the person doing the will or the trust. And you all understand this because you have the same privileges of privacy and confidence. Pastors and lawyers do. And so when that person is excused, then 9 times out of 10, the client says, oh, that's okay. I want my daughter in the room. But I have to tell you, 1 out of 10 times, the client says, thank you, Andrew. I don't want to change my will. My daughter tells me I should because she's helping me so much, but I don't want to change who gets what after I die. And I say, well, we're not going to do that. So we have to determine the intent of the client. And so when you wait till the last minute when you're sick or you know that you're going to die soon, it's the wrong time. The right time to do estate planning is now. And I can tell on this Zoom that all of you are healthy and have mental capacity, especially those of you with your pictures on. No, just kidding. So you look great. But isn't Zoom fun? I love it. I mean, here I am in Grand Island and we're all connected. I'm going to predict that lots of church meetings statewide will continue to be on Zoom. It's so convenient. I love it. So number 8 is a mistake that we see often, and that's failure to update an estate plan. My average new client is a baby boomer. I joke with my parents that I meet with them every day, but I really do. My parents are both 72 and both retired. My mom was a teacher in the Lincoln Public Schools and a big fan of Marilyn Moore, who I see is on this Zoom. And my dad, again, is a retired pastor. But they are exactly who I meet with every day, because the baby boomer generation is focused on estate planning. And oftentimes when I meet with new clients, they'll say, well, we did a will back when the kids were, in elementary school, and now we've got grandkids, so we need to completely change the plan. And so that's a typical update. We see a lot of people when they're at or near retirement age because it's a natural time. But other reasons to update are when you receive an inheritance. If you've been divorced, it's very important to change your estate plan because we don't want something going to an ex-spouse, for example. And there are other times in life, grandchildren are a good one to consider changing your estate plan, because a lot of our clients want to include educational funds or things like that for their grandchildren. But the biggest problem that we see is people not staying on top of new changes in the tax laws. And, this year we might see a significant change in our federal and state gift tax laws for the first time in quite a while. So let me just summarize those for you. We haven't heard a lot about the federal estate tax for a while because the exemptions have been very high, meaning that under current law, an individual has to have more than $11.5 million in net worth to worry about the federal estate tax. And so for the vast majority of our clients, they fall well below that $11.5 million. And we will even tease and joke about it. Well, we're not going to, unless we win the lottery, we're not going to worry about that. Well, laws change, and this has been an interesting ride for me. I graduated from law school in 1998. At that time, the exemption was $640,000. And sparing you the details, it's been very interesting over the last 2 decades. It's changed dramatically. Well, it might change again. President Biden's tax proposal is to reduce the exemption for individuals to $3.5 million. Now, he does include what was first introduced during the Obama administration, which is something called portability, which means the ability to port or transfer between spouses. So with proper estate tax planning, a married couple can shield double whatever the exemption is. So for a married couple, the exemption from the estate tax, this is the federal estate tax, would be $7 million, which still is going to put a lot of people in the clear. Now, our clients who are going to be concerned about a reduction from, in essence, 22 million to 7 million are our Nebraska farm and ranch clients. We work with hundreds of farm and ranch families across the state, and especially out here in central Nebraska, where the average farm is now about 900 acres, and land can easily sell for $8,000 to $10,000 an acre for good flat irrigated ground. You can do the math. That's about $10 million worth of ground alone. And then when you add on machinery and the like, most central Nebraska farmers are worth more than $7 million when they die. And so a lot of folks are going to be paying close attention to this. And maybe I should say when the new tax law passes this year, when it's going to be coming into effect. This is a big opportunity for charitable organizations. We have a lot of clients who will say things to us like, well, I want the kids to get everything they can get without paying taxes, but then give the rest to my church. It's a really fun opportunity. Again, am passionate about it, but I've had a couple of instances where we've left land to congregations or through the foundation for the benefit of a congregation. And it's just an awesome legacy gift. And the biggest motivating factor for people to do that is to avoid having to sell land for paying any taxes. This also works very well with qualified retirement accounts. Qualified retirement accounts, those traditional IRAs, those are packed with potential income tax events when the second spouse dies. You see, only a spouse or a charity pays no income taxes when it receives an IRA. Now, this does not apply to Roth IRAs, which are funded with post-tax dollars, but it's those pre-tax funded IRAs that you have to take out required minimum distributions from and pay taxes on beginning at age 72. It's those that are waiting to be taxed when the second spouse dies. And so a lot of our clients will leave their church a percentage of their IRA because we eliminate what could be a 20 or 30% loss by a child or a niece or a nephew from the IRA. We eliminate that lost revenue or income, and by simply leaving it to a qualified charity, which all United Methodist congregations are, since they're under the umbrella of the annual conference. And so it is great planning. It's a great opportunity. Stay tuned. I sense that given the changes in the law, that many of your parishioners will be more likely to want to leave charitable gifts. And so the timing's everything. The timing might be really right this year or next to have a presentation on that, have someone from the foundation come talk about that. I think we're going to see more opportunities. Mistake number 7 that I see a lot of people make is not dealing with their personal property. You know, when I meet with folks during their lifetime, the big topics are money, real estate, and vehicles. Those are usually what comes up. I have to tell you, after folks die, those are not the big issues. And many of you have been involved in some of these family disputes in and around funerals. The big disputes are who gets mom's wedding ring, who gets dad's shotgun. Those are the top 2. But beyond jewelry and firearms, family heirlooms, artwork, things that don't divide without selling them. If you have 3 children, it's easy to divide an IRA into 3. It's easy to sell a house and divide those proceeds in 3. It's impossible to divide your wedding ring. And it's the sentimental value of these items that drives the biggest fights. One of the reasons I am an estate planning lawyer who has never litigated is I am a conflict avoider. I do not like conflict. I do whatever my wife tells me to do, and it works out great. I would be a terrible litigation attorney because I'd have to sue somebody, which I wouldn't do. So I can tell you that the best way to avoid conflict after people die is for mom and dad or grandma and grandpa or uncle and aunt to deal with their personal property head on, especially our clients who have lived in the same place for 40 years and maybe don't sort very often. This can be a huge burden on the beneficiaries of the estate. It may take a year to sort through things and stuff, as I call it. But most importantly, the takeaway here is I would ask your children or your beneficiaries, are there things that you want? And the reply will come back, no, I just don't want you to die. And, these aren't fun conversations, but they're important conversations because you can flush out the issues. Like 2 people want that same painting because it hung in each of their respective bedrooms during their childhood, or 2 daughters want the same piano because they both learned to play on that piano. These are real examples I've had where there were a lot of hard feelings over dividing up the things and stuff. Now, our best advice with personal property, which is what I'm describing, is to give it away now. If it's something that you're not going to, like a wedding ring, if it's something unlike that it's okay to give away during your lifetime, like that piano or painting, give it away now. You get to enjoy seeing the person receive it, and then it's a non-issue after you pass away. But one thing I'd like to add is, in our practice, we attach what's called a memorandum or a laundry list to a will or a trust. That is where people can specifically identify who gets things like jewelry and firearms and artwork. But be careful, there are 3 types of property that you should not put on the laundry list because legally they cannot transfer. And those are the big 3 that I kind of mentioned before. Real estate. Real property is a unique asset. It takes a title or a deed to own. It doesn't work to say, okay, my daughter gets my house in Nebraska and my son gets my winter home in Arizona on a piece of paper. Those are deeded assets. We need to take care of those specifically. The second thing that cannot go on a laundry list is money, or any form that money takes. We'll talk about it in a little bit, but beneficiary designations, control over a will. It's extremely important that people review those beneficiary designations for life insurance, retirement accounts, annuities, 401ks. And then finally, the one that catches the most people unaware is anything else that it takes a title to own, like your motor vehicle. A car or a truck has a title as well. And you cannot leave that on a laundry list. Now, what you can do, which is super nice, is since 2008 in Nebraska, you've been able to take the deed, or excuse me, the title to your vehicle into the county courthouse or the DMV, where you get your license or your license plate, and you can actually put transfer on death right on there. And that is a really nice way to automatically transfer to an individual or a charity. I see a lot of charities get vehicles. I know Pastor Tom at the People's City Mission in Lincoln likes to get vehicles, but you know, and they give them to homeless people who've gotten up, you know, on their feet and through rehab and the like. So it's a really neat thing to do, but you can actually do that just right on the title itself. But everything other than vehicles, real estate, and money can go on these laundry lists. And they're very powerful and important to consider. And from my perspective, the best part is you avoid a lot of conflict after you pass away. The 6th mistake that I see people make is failing to plan for special needs. Is there someone special in your life that has a disability or cannot work because they had an accident? I have a lot of clients who have special needs children who are going to live with them their entire life. And then with somebody else after mom and dad pass away. A lot of times people think they're doing the right thing by leaving somebody who has challenges a lot of money. And actually, you may be doing them more harm than good. That is because if somebody who is on disability or receiving government benefits because they cannot work receives an inheritance, oftentimes that disqualifies them from receiving the government benefits that they would otherwise be entitled to. So that's a mistake. The better way to do this is to leave money to that special person through what's called a special needs trust. Special needs trusts are the loving and right way to do this because it does not disqualify the individual from receiving other benefits from the government, and it supplements those benefits. Maybe it gives them a little better place to live, pays for haircuts, better meals, things of this nature. It's very important to work with a qualified trustee when we're doing this. I'm a big fan of corporate trust departments. My friends Leslie and Kim, who work at UBT, are on here, so what up? And Union Bank is one of those excellent trust, I like that, one of those excellent trust companies that specializes in special needs trusts. This is not an area to go in when you don't know what you're doing, because the rules change all the time. And, you know, family members who are serving as, hi Kim, who are serving as trustee can unwittingly violate the rules. And so you want to work with a qualified trustee. And then the other good thing about this approach is when the special needs person dies, the money goes wherever you want it to go. If you don't set something like this up, when the special needs person dies, the money goes to the government to reimburse the government for its support. I recently worked with a wonderful family who have an adult special needs child who lives in a wonderful group home that has been very loving to him. And so I think this is cool. My clients are going to leave what's left over in his special needs trust when he dies to that group home, which is, I think, awesome and will help them. And so there's a lot of neat things we can do through that. But the biggest mistake I see is unintended usually. Usually it's a second order beneficiary. In other words, maybe you're leaving everything to your children, but you have a grandchild who has special needs. But in your will, it says that if one of your children dies before you, that child's share goes down to their children, your grandchildren. Whoops, you might have created that problem and don't know it. So be very careful in that regard. Mistake number 5. This is the question that Leslie, Kim, and I get more than any other. How do I avoid probate? Well, first of all, I'm going to say that although my friend Tom Roper has me do a series at Roper and Sons Funeral Home that he came up with the title, Is Probate a Dirty Word? Which is a catchy phrase for a seminar. Probate's not a dirty word if done correctly, and I'll talk about that. But most of our clients do want to avoid probate. And let me discuss what I'm talking about. Probate is the old-fashioned way to transfer assets through the court system. Now, there is nothing wrong with probate. I'm a probate lawyer, so it may not shock you that I would say that. But I was in probate court in Lancaster County yesterday morning. I had a tie on for the first time in a while. I don't know what happened. My shirts have shrunk during COVID. I don't know what happened there. Okay, anyway, I had to leave the top button unbuttoned. So need to work on that. But, probate court is where we admit the will to the judge appoints an executor, the executor goes out and collects the assets, and we administer it through the court system. This is what happens if you die without a will. It's also what happens if you die with a will only and not a trust. A lot of people think incorrectly that if you have a will that your estate avoids probate. That's actually not true. It's only with a funded trust where your assets are owned by the trust before you die where we avoid the court system. Now, what's so bad about the court system? Well, there are 3 things that beneficiaries of estates do not like about probate. I know because I'm a probate lawyer, so I'll tell you what they are. Number 1, people do not like attorney's fees. I know that. That's the number 1 reason over the last 30 to 40 years that many people have used trusts, because they don't want to pay a lawyer to transfer property from one generation to the next. Now, here in our office, we charge on an hourly rate basis. Some lawyers charge a percentage of the value of the estate as their fee, which you can imagine in a farm or ranch estate can be a very high fee. But even the way that we charge, which is on an hourly rate basis, it's going to be more than if you had avoided the probate, because you don't need us as much. There isn't as much legal work to do. So there are other reasons, which I'll discuss next, as to why you should look to avoid probate. But the number 1 reason that people do is to not pay an attorney a bunch of money just to transfer their estate at death. Other reasons that it's good to avoid probate are elimination of time delay. Boy, this was driven home to me last year. Our court system, you probably heard or read, shut down in April and May. I could never have ever imagined that would happen. We did not have probate court for 2 months. And so when I worked with families last year whose loved ones had died in February and March, and they got around to coming see me in April, I'd have to say, well, sorry, we can't open your mom's estate until June or July. What? Because I can't get into the court system. I can't list the house for sale. I can't get the money out of the stock market when it's doing this last spring. It was very stressful. And with a trust, your trustee, the person who takes care of your business after you die, that's what we call an executor with a trust-based estate plan. Your trustee can take care of your business immediately, the next day after the funeral, pay for the funeral. Tom Roper likes that part. And pay for your expenses, pay your income taxes right away, list that house for sale, get the money out of the stock market, give it to the beneficiaries. And so trusts are great, I believe, because it eliminates all of that time delay. Probate usually lasts 9 to 12 months. It has to last a minimum of 5 months. And with a trust, oftentimes we're done before that 5 months would have even run. And so that to me is one of the biggest reasons to consider avoiding probate. The final reason that a lot of people like trusts and avoid probate is to provide a modicum of privacy. A lot of our clients would just as soon you not know how much they're worth. There's a lot of good, frugal, modest Methodists who have a lot more than you think they do. And they like it. They like it that way. And I always love when somebody comes to meet with me that you would have no idea is worth $10 million because they live in a modest home that's paid for and drive a Chevrolet. It's also funny to me to meet with those, I don't know, doctors who come in and make a lot of money but are in debt up to their eyeballs and have no net worth. So I see kind of both sides of that coin a lot. But a lot of our clients don't want you to know what they're worth, and they'd rather you not know where their money is going to go. And so clients who are more private in nature love trusts because they're not filed as a matter of public record with the court system. You know, in the old days with probate, people could go down to the courthouse, check out the file, and read all about it. And they did. Nosy people would do that. Today, it's all online. Just like we're doing this online, if there's a probate, I can go online and easily access a copy of the will, an inventory of the assets of the person who died, see what they were worth, see where the money's going. So for privacy reasons, to avoid attorney's fees and time delay, most of our clients like to avoid probate. The takeaway on this one is the only way, as I mentioned, to really effectively avoid probate is to have a trust that's funded. Now, what do I mean by funded? I mean that it owns the property. So if you've done a trust in the past, but it doesn't own your home, for example, guess what? Your estate is still going to have a probate. And we see that a lot. We see people come in who worked with an attorney 20 years ago, their parents did, and now their parents died. And they say, well, good news, Mr. Loudon, mom had a trust, so there's no probate. I'm like, that's great. And then I say, okay, how did mom own her house? Well, just in her own name. Well, if that house is worth more than $50,000, which almost all homes are, guess what? We still have to have a probate. So if you have a trust and you haven't looked at it in a while and you're not sure, this is a good time to go back to your lawyer, go back to your financial advisor, go back to your accountant and say, are we using the trust correctly? Am I going to avoid probate? All right, mistake number 4 is failure to safely keep original documents. Now, this may seem funny, but I can tell you that it's about 3 or 4 times a year that we have clients call us and sheepishly admit, we lost the original will. We have no idea where it's at. Usually it's when we've moved, or maybe we're moving mom to assisted living and kids with the best of intentions threw it out because they were cleaning out the house. So I think it's very important to keep original documents in a fireproof place that we know where it's at. When you're working with a corporate trust department like UBT, one of the things that they offer free of charge, which is super great, is to hold the originals in their big giant vault at 27th and Pine Lake. I really like that because then we know where it's at and we're never going to lose them. For our clients who are not using corporate trust departments, our best advice is a safe deposit box where your personal representative or trustee has access to after you die. Now be careful because after you die, if your child, who's your personal representative, is not on the box, meaning they went with you to the bank and signed on the card to have access to the bank box, then the bank's not going to let you in. Okay, I know that's not true in Seward, Nebraska, because the banker knows you and they're going to let you in. I just had this last week and I said, oh, I bet you couldn't get in. And they're like, well, of course I did. I know everyone who works at the bank. Okay. In small town Nebraska, it doesn't work that way. But I will tell you, in Lincoln and Omaha, if your kid is not signed on, and probably in Grand, it's happened in Columbus that I know of, they're not going to let you in. So in our bigger communities, if you have a safe deposit box or a bigger bank, you're going to want to have the person come in and sign on the card so that they can access it. It's a catch-22 big time in an estate, because sometimes we don't know what the will says, but we can't get into the safe deposit box. There is a process for that. It costs attorney's fees. We go to court, we get an order from the judge in the county, we go to the bank officer, it's appropriate, is there, opens the safe deposit box. The will's actually delivered to the court, so the court can see it first. But that's all unnecessary attorney's fees. So the easy button on this one is to get your kid, when they're in town, to come put their name on the safe deposit box. Okay. Mistake number 3 could be its own seminar. And in fact, Matt, I would offer that sometime if this group wants to really delve into Medicaid issues and long-term care. This is increasingly becoming a big part of our practice, counseling families on how to deal with the devastating costs of long-term care. I know all of you as pastors are dealing with that with parishioners. You know, in Lincoln, the average cost a month is $8,000 to $10,000. It's just unbelievable. You know, and with higher levels of care, say Alzheimer's and things like that, I have a client paying $17,000 a month. And so it's pretty easily will bankrupt somebody, especially for clients who own farm ground. This is scary, because once you spend down, and that's the term, the money that you have in investments in the bank, then you have to sell the land that's been in the family since 1903. That's my wife's family. My wife's from Hooper, Nebraska, and her parents farm on the Elkhorn River just north of Winslow, and that farm's been in their family since 1903. Well, it would be a tragedy if they had to sell that farm to pay for long-term care. And so we do a lot of counseling. There's a lot there. I'm not going to get into much today, other than the biggest mistake that I see made, and I'd like to share this with you, and that is married couples where one spouse is in assisted living and the other one is at home, unnecessarily spending down assets they don't have to. So let me please address that. I've met with a lot of families who have one spouse in assisted living and one spouse at home, and they come to see me, and it's really sad because I find out that they've spent money they didn't need to. Oh, here's my law partner, Kara Brostrom, who's a Grand Island native, bringing me lunch. She's way too nice. She's got her mask on. Okay, all right. Thank you, Kara. These are 25 United Methodist pastors across the state. Okay, so anyway, these are the rules for the community spouse. So the community spouse, the person at home, gets to keep the following: the home. That is a big deal. We changed those rules in the 1980s. This is called spousal impoverishment rules. The house, if one spouse is at home, does not need to be sold. The spouse at home gets to keep all the personal property, all the things and stuff that we were talking about before. That's huge. The spouse at home gets to keep one vehicle. I have a lovely client in Lincoln who I affectionately refer to as the Lexus lady, because she came to see me when her husband was going into assisted living. And I said, "What kind of car do you drive?" She said, "Well, a Toyota." I said, "Don't you think you should have a Lexus?" See, it doesn't matter how expensive the car is. She went and got a Lexus. It's pretty nice. And these are brutal discussions to have. It's not fun talking about it, but you have to kind of bring some levity to it. And then this is the big mistake. That spouse at home not only can keep the house and a vehicle and all the things and stuff, they can keep an amount of money that's indexed for inflation of now $123,000. Again, I've met with clients who have already spent that money and didn't need to, because that is what the spouse can keep, and their spouse in assisted living can go on Medicaid, which is the government program to help pay for long-term care for people who are 65 years or older and impoverished at a $3,000 or less level. And there's a lot more to be said on that. And like I said, if you'd ever want to do a more in-depth seminar on Medicaid and qualification, that might be helpful to your group. So the number two mistake that I see people make, and I'm thinking about changing my list. I think this is the number one mistake. So pretty soon I'm going to flip these, but the number two mistake that I see people make is naming the wrong person to be your executor. You can have the nicest looking estate plan, well drafted, but if you name the wrong person to be your executor, it's not going to go well. Do your children not get along with each other? Don't name one of them over the other. Are you treating your children in a way that you view as fair but is not equal because one child never paid you back a loan that they owed you? Please don't name the child who's getting more to be the one to deliver bad news to her brother that she gets more than he does because he never paid mom and dad back. Do you have a larger estate? Do you have a child with special needs? Do your children or nieces and nephews live on the coasts, nowhere near Nebraska? And are they busy people who are not going to have the time to settle your estate? All of these are reasons to think about naming an independent third party. Now, I'm not saying this just because Leslie and Kim are on. I say this to every group. But I am a huge fan of the work that Union Bank and Trust does because they remove the family dynamics. So now if people are going to get mad at somebody, they're going to get mad at bricks and mortar. They're going to get mad at a professional whose day job it is to administer estates. When you name a corporate trust department in your documents, the best part is they don't charge you until you die. You know, a lot of people are always concerned about the cost, but you shouldn't be. The fee schedule is real straightforward. It's typically around a 1% fee, which may sound like a lot of money, but what a corporate trust department does is everything from making sure that the funeral is paid for to making sure that your final income tax return is filed and everything in between. Kids love it when a corporate trust department is involved because they don't have to do anything. We've relieved the burden from them. And then most importantly, from my perspective as a conflict avoider, we're going to preserve maybe families getting together for Christmas and Thanksgiving. Whereas I see so many families, especially when there's one child, and you know, a lot of my clients will say, well, we'll name the oldest. That's not a good reason to name somebody as your executor. I mean, you got to name somebody who is organized, who has the time, who is not a procrastinator. And a good option is to name a third party or to name one of your family members who is very responsible and then back them up with the corporate trust department. We just got done with an estate for a client of mine who lived in Lincoln, and she had named her son, who lives in New Mexico, who is literally a rocket scientist and is very busy, and Union Bank as his successor. Well, it worked out great because he actually worked with one of Leslie and Kim's colleagues to work together on it, and they kind of split up the duties. So that works too. So there's a lot of options out there, but the bottom line is, please don't breeze over that decision. It's the most important decision that you're going to make is who is going to carry out your wishes after you're gone. My mistake number one, and then I'll take some questions if there are any, is having the wrong beneficiary designations. This is a biggie. I'd mentioned it earlier and it bears repeating. It does not matter what your will or trust says if your beneficiary designations say something else. If you have somebody else named as the beneficiary of your life insurance or your individual retirement account or 401k or annuity or a transfer on death on a bank account, that's the person who gets it. It doesn't matter that your will says your estate goes to your 3 children. If you co-own all the money in the bank with your one child because she helps you pay your bills, guess what? After you die, she owns all the money. Is she legally obligated to share it with her brother and sister? No. Is she morally obligated? I would say yes. The pastors here would find it interesting that I have a lot of conversations with people about the moral right thing to do, which is not necessarily the legal thing to right legal answer, because that's the best example I can give you is when I'm meeting with a surviving child who owns all the money and she asks me, do I have to share it? I say, what would your mother want? And if you don't do that, she's going to come back and haunt you. Okay, I know that doesn't fit with Methodist theology, but it's a problem. And so the best way to deal with that is through powers of attorney. Have your child who helps pay your bills have your power of attorney instead. Through trusts, a lot of our clients have will have a trustee like Union Bank named, so that if they become mentally incapacitated before they pass away, UBT takes care of paying the bills. But then after somebody dies, the money goes where you want it to go. And that's my number one goal as an estate planning lawyer, is that the client's intent is carried out, that their estate goes where they wanted it to. Sounds easy, but it actually is not that easy. And this is where the devil's in the details, is beneficiary designation. So if you didn't hear anything else that I said today, please double check who the beneficiaries are of your life insurance and your retirement accounts. So those are my top 10 mistakes. And I would be pleased to answer any questions that any of you have.
Andrew, you addressed federal estate tax really comprehensively. I think there are some differences at the state level. Is there any, just one or two sentences that we should think about in terms of state estate tax?
Yes, Dr. Moore, I will address that. Thank you. That's a great question. So in Nebraska, we have our own inheritance tax. If you are a native Nebraskan, you probably know that because you've had a loved one die, and this tax has been around since 1901. If you're not from Nebraska, this might surprise you. We have a tax. It's very unique, like many things in Nebraska, like our one-house legislature, and it's nonpartisan. We have an inheritance tax that's collected at the county level. We're the only state that does it that way. That's the political reason that it still exists. Our counties are very jealous of that revenue source and don't want to give it up. And then we also tax people, this is also unique, based on how they are related to the person who died. Charitable organizations, like the Nebraska United Methodist Foundation, how is that? Do not pay any inheritance tax. Spouses do not pay any inheritance tax. But in Nebraska, we tax children, grandchildren, brothers and sisters at a 1% rate after a $40,000 exclusion. We tax remote relatives, nieces and nephews and cousins and uncles and aunts at a high 13% rate after a $15,000 exclusion. Ouch. And it gets worse. We tax non-relatives at an 18% tax after a $10,000 exclusion. You may have read in the paper last weekend that there was a hearing last week in the Nebraska legislature on potential reforms to these percentages. Senator Linehan from Omaha, who chairs the Revenue Committee, was quoted as saying, "It seems like these rates are stuck in history," and they really are. They haven't been revised for a long time, and I'm very hopeful that the legislature will see fit to reduce the percentages, especially for nieces and nephews. I feel that I don't use the word fair very often because in my world in estate planning, fair is in the eye of the beholder, but I do not think it is right to tax somebody like a niece and nephew at such a high rate. In effect, punishing somebody for not having children is the way I kind of look at it, because, and that's my personal opinion, but I don't like that because, well, I get to deliver the bad news a lot of times to nieces and nephews. Just did it this week already, that you're going to lose 13% of your inheritance from your aunt. But that's the way that the law works in Nebraska. A couple caveats. Sorry, these are more than a few sentences, but I think it's a good question, Marilyn. We do not tax real estate in another state. So if you own a farm in Iowa, that's not taxed by the Nebraska inheritance tax. And we do not tax life insurance benefits to a named individual. Be careful. A trust can be a named individual, but if your life insurance goes to your estate, then it is taxed by our 13% tax. I had a real sad situation a couple of years ago where somebody who I didn't work with during lifetime thought she was doing the right thing to avoid this by having her nieces and nephews be the beneficiary of her will and then leaving her life insurance to her estate. Well, actually, it was the opposite. She should have had the nieces and nephews as the named beneficiaries on the life insurance, and then there would have been a zero tax. As it was, we lost 13% to the county. So thank you for that question, Marilyn. That's a unique Nebraska thing.
Well, one thing that had occurred to me as an unmarried person, that I needed to make a list of where my assets are, because my heirs wouldn't be able to find them. I get all my statements by email now, so they wouldn't be able to find bank accounts. So I do have a list with account numbers in my safe deposit box accessible to those folks. So I just thought that was something that had occurred to me.
It's very smart. And I would add that passwords are a problem for us after somebody dies. Now we're required to change our passwords every 3 months, it seems. And so in addition to that, I know it's a lot of work, but I would strongly encourage you to include passwords to anything. Like you said, you receive all of your statements online. We have a company in Lincoln that can crack the code, but they're expensive. And so we use them quite often. We've also updated all of our documents to allow for digital access by personal representatives and trustees and powers of attorney during lifetime. But you're right, Thomas. Almost everything now we receive electronically. And if no one knows how to get into your iPhone or your computer, it's going to be very difficult after you pass.
Andrew, that last one you mentioned with beneficiaries, I guess I'm like Tom, I'm also single. Actually, my pension beneficiary is my father, who died in '86. So I need a little work on that. My executor is a brother that died 10 years ago. I guess one of the things I thought about was, as you mentioned, naming, you say name a name a trust department. As you can name a trust department as a beneficiary, but don't name the estate.
You don't want to name the trust department as a beneficiary. That's who gets the money. But you can name a trust department as your executor. So, so the beneficiary is who gets the money, and then the executor is who makes sure that that happens. Now, it's automatic with most beneficiary designations. So really what we're talking about is who's going to deal with your personal property, things of that nature. But again, that's a service that most trust companies provide. Union Bank does, and others do. And especially if you don't know who to name, that's a really good choice, in my opinion, because we know that somebody will be there to carry out your wishes after you've passed. But on those beneficiary designations, whomever you name, individual or charitable organization, they're going to get that money if they survive you. See, the situation, and this happens all the time, Dale, you are not alone. We have estates at least once or twice a year where someone who's already died is the beneficiary. And so it gets interesting because it depends on the rules of that company. Sometimes they'll make us, and it's frustrating, go open an estate for your dad, for example. Other companies will not and allow it just to revert to your estate. So every company is different in their rules, but we don't want to leave it up to them. We want you to decide who gets the money.
Right. Thank you.
You bet.
I have a suggestion about the passwords.
Okay.
I use a program called LastPass, which remembers all my passwords, and they have a feature called Emergency Access, which you can give people a special username and password, and allows them in only after you haven't accessed it for a certain period of time, a month or a couple of weeks, and then they can get in and find all your passwords. So that's one possible help for that.
That's awesome. I was not aware of that. That's super cool.
Tom, what was that program again?
It's called LastPass. There's a free version, but I like to pay for it so they stay in business. But but I mean, it keeps, you know, every important site I have has a different username and password, so it keeps things pretty secure.
I wrote that down. Thank you very much. I always learn something new every day. That's cool. Oh boy. I just noticed there's a judge on here. Who didn't warn me that Judge Parch was going to be on here? Hello, Your Honor. I hope I didn't say anything wrong. One of your members in Nebraska City is our judge in Odo County. So now I'm going to be thinking about what I was talking about.
Fortunately, we recorded all of it, Andrew, so we definitely can, we can definitely help you make sure everything you've said is still there. So
Too late.
the judge is saying hello. The judge says hello on chat. So so that's just so you're aware.
Cool.
Are there
No,
any other questions?
I would just like to chime in. Andrew, thank you. You always do such a nice job. As you all are working on your estate plans and working with your congregations, you know, many times we will have customers who think that or talk about doing their estate plans online at something like legal.zoom.com. And I always want to encourage individuals, go to Andrew, make sure that you're having those documents done by a good estate planning attorney. And we're fortunate to have Andrew and his team available to help. So that is also just words of wisdom to pass on to those that you work with.
And I have one final comment about Andrew's mom, since Andrew mentioned her. She was a first-class vocal music teacher in Lincoln Public Schools. Grand teacher.
Well, I'm biased. I agree, but I'm going to pass those kind words on to her. You're the best.
She was great.
Thank you. She sure misses LPS. When they moved to Florida, it just was not the same. I bet you hear that a lot.
You do hear that a lot.
Mhm.
All right, this might be the quietest I've ever heard a group of clergy in my life, but any other questions, comments, observations? All right. Well, again, Andrew, thank you.
Andrew.
Better than average chance. We're going to be looking at that Medicaid and long-term opportunity here in the near future. So,
Okay, I'd be happy to
thank
help.
you.
That's a big one. Yep. Okay.
all right. We're going to record this. We're going to load it up on the YouTube channel. So if anybody wants to look at it later or share it with others, it's available to be done. I hope you all have a wonderful day. Take care.